This is Lecture 19, PostGrant Administrative Proceedings. The agenda for this lecture is to look at patent screening policy to begin with and talk about the basic idea, the policy that we use for screening patent applications. And then we're going to talk about different types of administrative post-grant review procedures. First, reissue. Second, reexamination. And finally, a look at the new post-grant review systems that the American Invents Act introduced in recent years. So let's move into patent screening policy. So the first thing to think about is how do we evaluate patentability right now in terms of determining whether a particular invention meets the standards for patentability. All right, so here's our standard diagram of the life of a patent. You have an invention, you apply for a patent, there's a prosecution period, the patent issues, then there's an enforcement period, and then eventually the patent expires. Right? So we generally think of the following, right? We evaluate patentability in a few places. First, the applicant, him or herself, will evaluate patentability at the pre-application drafting stage, right? They may do a prior art search or may not. You're actually not required to do a prior art search at all, but you may if you want to, because that may help you draft claims. But in any event, most applicants do at least some sort of analysis as to whether or not the invention they have is able to meet the standards for patentability. Then there's the prosecution stage, right? And of course, prosecution means that there's a patent examiner who works for the United States Patent Office evaluating the patentability of the claim. After the patent issues, judicial review takes over, meaning that if the patent is litigated, then the court in front of whom the litigation occurs can determine the validity or invalidity of the patent. And so let's think about how those are different. Right? So in the pre-application stage, the cost of the review varies because it's primarily at the discretion of the applicant, him or herself, right? So it might be nothing and it might be very extensive. The expected accuracy, well, it might be low because there's not a lot of incentive to do a ton of this work or to get it right. On the other hand, there's some incentive to get it right because if you know what you're up against, you're more likely to draft claims that are going to go through the office easier and take less time and so forth. The primary direct cost bearer is the applicant or the inventor. All patents get some sort of pre-application review, right? I'm going to just assume that people don't file patent applications without at least some level of analysis as to whether the thing is patentable or not. And so, that's right now about 400,000 applications a year. What are the costs? However much it costs times 400,000, right? So it could be significant. Prosecution, the cost is relatively low. We know from statistics from the Patent Office that somewhere between 10 and 30 hours is spent per application. The expected accuracy seems pretty low. I mean, the studies that have been done show that in litigation, approximately 50% of patents, a little less, 40 to 50% of patents are held invalid. The direct cost bearer is the government. This is a government agency that's doing it. How many are reviewed? All of them, right? 400,000 per year. And so the total costs are that low number times 400,000, right? Finally, there's judicial review, right? What's the cost? The cost here is extremely high, millions of dollars, right? By most estimates, you're probably talking, at least 3 to 4 to 5 million for any type of significant patent litigation. And if it's a big case, you're talking tens of millions of dollars of potential fees and costs. The expected accuracy, well, I think there it's pretty high, in part because of the cost, right? There's going to be lots of expert testimony. There's going to be plenty of time to think about it. There's going to be multiple decision makers if you include appellate work and so forth. So at the end of the day, the accuracy is probably going to be pretty high. Who bears this cost? Well, the government bears a lot of the cost because the government runs the court system, and the parties involved, right, are going to bear a very significant amount of the cost, right? How many? Very, very few, right? Only about 1,000 a year are reviewed in this way. And so you've got an extremely high cost times 1,000 as your total cost, right? So here's the question, right? And basically what we're talking about in this class is there another place we could evaluate patentability? Call it administrative review. During the enforcement period, right, after a patent has been granted, can we do something? Some sort of administrative review that would enhance our situation, right? So let's think about it, right? So let's add to the bottom here, right? Let's say if we could do an administrative review that was relatively low cost. Why would it be lower cost? Well, maybe the standard rules of evidence don't apply. Maybe you use, instead of full-blown district court judges, you use specialized judges or a special tribunal. Something to keep the cost down where you can. The question is, can you have high accuracy when you have lower costs like that? Maybe you can. A lot of people think that you probably can still get very accurate decision making, even without the full cost of traditional litigation. Who's going to bear the cost? Well, the government, because this would be some sort of administrative body doing it. And the parties might, if there's fees or costs associated with this. How many reviewed? Well, so the idea here is instead of reviewing everything, you would review those patents which are important, which deserve some sort of review. And how would we know that? Well, probably they would be the ones that are important in the marketplace, and therefore the ones that are sort of attracting attention. Either they're being litigated or they're worth a lot of money. And in any event, it's worth it to somebody to try and get an administrative review started for the particular patent. And so the issue is the total cost would be sort of medium costs times however many are done, few to medium, a lot more than 1,000 perhaps, but far, far less than the 400,000 per year. And so the idea is there a sweet spot in here that we're highlighting of administrative review that's going to allow us to gain some efficiency in patentability reviews over and above the pre-application, the prosecution, and the judicial review concepts. And that's what this class session is about, is trying to figure out whether we can do something like that, right? And so, you can think about this in terms of the impact cost ratio, right? So the impact cost ratio, I think, of pre-application is pretty high, right? Why? Well, because the cost can be quite low, and yet although the accuracy is probably fairly low, although it could be very good because a patentee has a lot of information about whether his or her patent is valid. But I think it's a high impact per cost because every single patent is being done, right? So it is a review method, this pre-application review method, which again is not required, is not part of the statute, it's not an administrative body, it's just the incentive structure suggests that at least some of this is going to happen. And so I think it's a high impact, right? I think prosecution is medium to low impact cost ratio. Again, it's relatively high impact in the sense that every single patent is prosecuted. Unfortunately, because every single patent is prosecuted and prosecuted in the same way using the standard procedures, it is difficult for the PTO to vary the amount of resources spent for more important patents. And indeed, they probably don't even know which patents are the more important ones, and so they can't sort of vary the impact. Right? I think the judicial review approach has very low impact. There's just not enough patents that are reviewed. 1,000 a year is just nothing compared to the 400,000 that come in the door at the patent office every year. And so although the accuracy is quite high, the impact is quite low. And the hope is that this administrative review could be high impact, right? That the bang for the buck for administrative review could be quite high because you could do a lot more patents, review a lot more patents than litigation could, and yet keep the costs down, and yet be relatively accurate. Maybe not as accurate as full-blown litigation, but at least some more accurate than prosecution. Not do all patents, but do a lot more than just litigated patents. And the hope is, and the theory is anyway, that there's a sweet spot somewhere in there where you can be high impact and you can do a lot of good for weeding out bad patents by having some sort of administrative body. So Whether we've actually hit that sweet spot, I think, is open to discussion, and I think we will discuss that when we meet in class. But I'll give you the sort of outline in this over the next 40 minutes or so about how the different types of review are going to work. I also want to say, before we leave this point, this policy point, is I actually, if I had my choices, I think I would focus more on that pre-application review, right? Which is really, although not mandated, is really all about incentives. And it's all about thinking about the incentive structure of patent applicants, and trying to induce them to do more work up front, which is going to save the government, the PTO, and ultimately the judges, the competitors, the public, a lot of work down the road if they can do work up front with regards to evaluating their patentability and frankly not playing games with trying to get claims that, for example, are broader than they should be, or more vague than they should be, or with less disclosure than should be, and so forth. So I think that one of the underappreciated elements of the patent review system is the pre-application review, because we focus so much on the formal requirements, the prosecution, the judicial review, and the post-grant review, the administrative review, that we sometimes lose sight that applicants have a pretty strong incentive to do this even prior to applying for the patent. The other thing that people point out a lot is to ask, well, why couldn't we just do better, right? Why couldn't prosecution just be better in that context, right? And I've actually done a fair amount of research looking at international patent offices, in particular Japan. And in the end of the day, the thing here is that patent prosecution is just really hard, right? You're dealing with just enormous numbers of kinds of technology. The idea of patent prosecution, the best kind of prosecution gets the right prior art in front of the right examiner at the right time. That's a very difficult problem, right? And it's particularly difficult, in my view, when you have, like we have in the U.S. system, so many incentives for applicants to make vague claims, to not disclose fully, and so forth. So I think that we shouldn't expect, no matter how much money we try and spend on the PTO, that the accuracy would get much off the low end. I mean, it's possible you could double the amount of hours that each examiner spends on a patent application. Now, that would, of course, double the cost of the PTO. That money has to come from somewhere. Presumably, you'd charge more in fees or something, but in any event, it's not clear to me in looking at the Japanese patent office, where they do spend more time, and they still have a significant problem with a lot of invalid patents being issued. So it's just not clear that we'd get a lot of bang for our buck in doing so. And the problem, again, is informational problems, uncertainty, and under-resourced, right? That's the core problem with patent prosecution as we know it now. Why is judicial review high accuracy? Well, it comes down to resources, right? There's an enormous amount of resources applied to it, which allows for extensive fact-finding. It's a fully adversarial proceeding, meaning that every stone will be turned over, looking for potential prior art, looking for the right expert witness to testify on any particular issue. And so it's very resource intensive, lots of people involved, and so therefore the accuracy is very good. I mean, I think that in most cases at the end of the day, the courts are going to get this right. It may take an appeal to the Federal Circuit to do so, but it will likely get it right. So that's something to consider, but the costs are so high. I mean, this is why you get accuracy, is because you're spending, the amount of money that gets spent is just tremendously more than any other type of patent review. And again, the question is whether administrative review, whether it's possible to spend less than litigation, get almost as good a result in terms of accuracy, or at least a lot better than prosecution. And that's really the $64,000 question. Can we do that, right? You have to be lower cost, higher accuracy, which means higher efficiency, right? And that is sort of the holy grail of patent review systems, and whether we're able to do it, I think, is an interesting question, right? So here's the sort of strategies that we use for this, right? For this type of administrative review. We use an administrative agency for decision making, right? So that means it's lower cost than fully private adversarial proceedings. And it also allows for high expertise, right? Over time, the administrative body will generate expertise in deciding these types of cases. You conduct a small number of reviews on only the important patents, right? So that the resources are much more targeted than patent prosecution, right? Much more like litigation, where again, only the valuable patents really are being litigated, because why would anybody litigate a patent that had no value, right? So if you conduct a smaller number of reviews than you do in prosecution, and you do so on only the important patents, you can be more efficient. Maybe you introduce some adversarial processes, right? Adversarial processes, we think, allow for higher accuracy. It generates more information for the decision maker. Costs more, right? It can generate more costs, but it definitely introduces higher accuracy. And you exploit the time and the private information, right? So by doing it post-grant, right, sometime down the road after the invention has had time to be commercialized, all of the commercial options have been explored, I think you get a better sense at that point of which patents are more important and less important, right? I mean, in theory, the PTO could target resources on the important patents in the prosecution process, but the problem is before a patent has even been granted, it's extremely difficult, frankly, if not impossible, to determine which ones are the important ones and which ones are unimportant. The longer we wait, right, so the deeper into the enforcement time we go, the more information we have about that patent and about whether it's going to be a valuable patent or not, and what to do about it. So part of these administrative review strategies take advantage of post-grant by allowing people to wait before they file. Turning now to reissue. So reissue is found in section 251, right? And what the basic regime here is that whenever a patent is through error without any deceptive intent, deemed wholly or partly inoperative or invalid by reason of a defective specification or drawing, or by reason of the patentee claiming more or less than he had a right to claim in the patent, the director shall, on the surrender of such patent and the payment of the fee, reissue the patent for the invention disclosed in the original patent, and in accordance with a new and amended application for the unexpired part of the term. No new matter shall be introduced in the application for a reissue. No reissued patent shall be granted enlarging the scope of the claims of the original patent unless applied for within 2 years from the grant of the original patent. Right? The key here is that you have to show, in order to reissue, you have to show the director that there's been some error. That error could be that the patent is invalid, or the error could be that the patent isn't invalid, but you didn't claim as much as you thought you should, or you claimed improperly in some way. Importantly, note that according to 251, you can't enlarge the scope of the claims except within the first 2 years of the grant of the patent. Right? So it requires an error in the original patent, some sort of error. Reissue is very rare. As of the end of 2011, when I last looked, there have been 13,800 reissues since 1976. That compares with just over 4 million total patents granted since then. So that's 0.3%, right? So that's a very, very small rate of reissues. So reissues are very rare. And claims may be enlarged, but only within the first 2 years, and they're only done by the patentee. Right? So this is an important thing to note, which is unique among the types of review systems we're talking about today. The reissue system is one that is done only by the patentee. Right? So the issue here is one of the issues that comes up, of course, in reissue is the recapture, is how much the patentee, whether the patentee can use the reissue process to, in a sense, recapture information that had been surrendered during the original prosecution. And the answer is, of course, no, right? You wouldn't want to have a system that allowed the patentee to get additional bites at the apple. You want to keep it so that the patentee gets one patent prosecution. If there's a significant error that in the application, you need to provide an error correction mechanism. That's what Reissue is for. But you don't want to allow patentee to reobtain material that had already been surrendered. Now, the complexity is what was surrendered, right? And so this always requires a careful analysis of what the prosecution history says, what the patentee did during prosecution, and so forth, right? And so for that reason, the recapture rule is pretty difficult to apply because it takes comparing what was done before, what was precisely surrendered, to what happened during reissue, right? Why have this rule? Well, we just talked about it, which is that you wouldn't want to have a system. It would sort of demean or cheapen the original prosecution. It might allow patentees to get multiple bites at the apple, hoping that they'd get something that they otherwise weren't entitled to, and so forth. Why have this rule? We just said why we had this rule. Doesn't the 2-year limit solve this? Probably not completely, although it certainly limits the problem, right? I mean, I think that the issue is broader than just the two-year limit rule, which is, we want to make sure in establishing administrative systems that we protect the integrity of the original prosecution process, right? So we want to make that original prosecution process the key prosecution process and have the reissue be limited to error correction and not just a do-over of the entire thing, because that would shift resources away potentially from the prosecution process. So that the 2-year limit for expanding claims doesn't really fully capture this concern. So can you add new claims during reissue? The quick answer is yes, you can, right? Within 2 years, you can probably add new claims and new claims that are broader, right? And you can, of course, add narrower claims as well, right? So claim language can be changed during reissue. And one question is this a fair approach? I mean, are there notice problems here? And you might argue there are, right? I mean, what's happening here is a patentee is getting a granted patent, and then they are able to use the reissue process to sometimes quite dramatically change the scope of the claims. Again, you can only broaden within 2 years, so the impact is somewhat limited, but even within those 2 years, you can imagine that there's significant notice problems with that fact, right? So, I get granted a patent that says X, and then I get a reissue, and now all of a sudden my claims are, X times 2, much broader. That is potentially, I think, a significant notice problem. And because of that, there's the doctrine of intervening rights that goes along with the reissue analysis, right? And the basic idea here is that when you broaden your claim, you cannot capture subject matter where the infringers relied upon the original patent scope, right? So the basic idea here is the public has a right to rely on your original patent and make decisions concerning the original patent scope up and until your reissue patent is granted. Right? So what happens for intervening rights is if you make, use, sell something which did not infringe the original patent prior to reissue, then those will be protected. Right? Those are not eligible to be infringing the reissue patent. Right? The more interesting and the more complicated problem is number 2 here, which is, well, what if you haven't actually made anything yet that would infringe the original patent, but you have made substantial preparations to do so, right? You maybe have built a factory or made distribution agreements or accepted proposals to build a particular product. And then this reissue patent pops out and the claims are different and now they're broader and they could potentially cover your knew the product you were planning to build. There, the court does what it calls equitable intervening rights, and the court will attempt to use principles of equity to determine whether or not intervening rights should apply and prevent you from obtaining coverage, you as the patentee from obtaining coverage over those potential infringers who've made substantial preparations. Right? So the key case on this is the Seattle box case. Right? Seattle box had an original claim where there was a spacer. This was a method. These cardboard spacers were a method of stacking pipes on a flatbed truck. And obviously, if you put pipes on a flatbed truck, they'll roll everywhere. So you need spacers so that you can stack them high and that they don't roll and they don't get crushed and those sorts of things. Right? And the original claim said the spacer height was greater than the pipe diameter, right? And then they reissued that patent, and they had a reissue claim. A spacer height was substantially equal to or greater than the pipe diameter, right? And so the question is, so that's what happens. Industrial, the accused infringer, shipped some spacers after reissue, right? So after reissue, they shipped spacers that were 1/16 inch shorter than the pipe diameter, right? The court determined that these infringed the reissue claim, right? Query why that's, I guess the court called it substantially equal to the pipe diameter, and they were from pre-reissue inventory. Right, so the question in Seattle box is, are there intervening rights here? Right, and the court decides there are equitable intervening rights because even though the patentee was selling these goods after the reissue patent had been issued with the new claims, these were from pre-reissue inventory. Right? And the court went through the facts and found that, among other things, this was from pre-reissue inventory, so they had existing investments in this inventory that would have been a loss as a result of the reissue patent. They had existing orders at the time of the reissue patent was granted for 114 bundles of these spacers. So a significant amount of orders had already been placed for the pre-reissue that they had not yet shipped at that point. And so the court says that you are allowed, as part of the equitable principle of intervening rights, to use the pre-reissue inventory under these situations, even if what you're doing is shipping goods after the reissue patent has been granted and you infringe the reissue patent. Right? And so in this case, the court did find intervening rights. Next, we move on to reexamination. So reexamination is effectively just a do-over of examination. Right? And the way that this works is that it starts with a request to the director of the patent office, a reexamination request. This request can come from anybody. The request must demonstrate that there is a substantial new question of patentability based on prior art that needs to be reviewed in order to maintain the integrity of the patent system. Right. So basically, if you want a patent to be reexamined, you file a reexamination request with the director of the PTO, arguing and showing evidence that there is a substantial new question of patentability based on prior art. Right. And the decision whether or not to reissue to re-examine a patent is entirely at the discretion of the director, who is supposed to issue a decision. If the reissue request or the re-examination request is granted, then effectively it goes into a do-over of examination. Right? It's not quite a do-over because there's a couple things that are different. Actually, a few things. First, there's some ability for a third-party requester to participate. participate in the sense that they can supply prior art and make arguments to the examiner. They can't, it's not a truly adversarial system in the sense that you can respond to each other's arguments, but a third-party requester can essentially provide information to the examiner doing the reexamination. The other thing that's important is that this new examination cannot consider anything that's already been decided in the earlier examination, right? So this is, again, to protect the integrity of the original prosecution process. So if a particular piece of prior art was considered and it was determined that the claims are patentable over that piece of prior art, you can't use that. That can't come up in reexamination, right? It's done. It has to be a substantial new grounds of patentability and cover areas that were not covered before. And then claims may never be broadened during reexam. That's a rule, an ironclad rule. And again, the idea here is to try and protect the public notice function of patents. Once a patent is granted, it's pretty problematic to allow people to change the scope of the claims, and reexamination can't allow that to happen. And so unlike reissue, where within 2 years you can broaden your claims, subject to intervening rights, of course, in a reexamination process, you can't broaden your claims at all. And then the end result of reexamination is a certificate of reexamination, and then the new claims have the same effect as reissued claims, right? There might be intervening rights, depending on, although it seems unlikely since you can't broaden them at all, but to the extent that they've changed in some manner that would affect a potential infringer, then that's a possibility, although it rarely comes up. And they get the rest of the patent term that's still due to the patent. Right? So that's the basics of reexam. Quantum versus Rodime deals with a case where the question is, as you might imagine, tricky as to what we mean by broadening a claim. Right? So there's an ironclad rule about reexamination that you can't broaden a claim. The key claim language here was at least 600 TPI. And during reexamination, the patentee added the word approximately to that claim language. So instead of reading at least 600 TPI, it now read at least approximately 600 TPI. Right? And what Rodime argues is that does not broaden the claim at all, because a person of ordinary skill in the art would have understood that that the words at least 600 TPI includes the word approximately, that a person of ordinary skill in the art in the relevant field would have understood that saying at least 600 TPI means, in effect, at least approximately 600 TPI, right? The court just doesn't buy this, right? And it's interesting that this case, which is a reexamination case, and it's about whether or not you've engaged in behavior that's impermissible under reexamination, it's really a claim construction case, right? I mean, again, it shows you the importance of claim construction. It comes up in almost every area of patent law, right? So this just comes down to a question of claim construction. Is it true that original claim that didn't have the word approximately in it, is it true that people of ordinary skill in the art would understand that the scope of that claim included the word approximately? And the court just simply says no. Says that is not true, that there's no reason to think that a person of ordinary skill in the art would have understood anything other than there's a range there that is 600 TPI or less, and not more. And that's what the court says. Now, the interesting thing about what happens here is that the penalties for broadening your claim during reexamination are extremely harsh, right? This patent is invalid. Right? This is an invalid claim because it was broadened during reexamination, and therefore it cannot be enforced against anybody. Now, there might be other claims of the patent that were not changed, not broadened, and those may be still in effect, but this particular claim is invalid. And the court actually notes that you can't now go to the patent office and try and change the claim. It's once it's declared invalid, it's done. Once you've tried to broaden it during reexamination. So it's a harsh remedy, and why? Well, I think, again, part of the design of these post-grant administrative reviews is to try and avoid undermining the original prosecution process, right? We want to make sure that patentees give their best effort, their best job during the original patent prosecution process, and not try and use some of these post-grant proceedings to get something that they might not have been able to get. And so for that reason, we make the penalty for broadening claims during reexamination quite harsh, so as to dissuade people from even trying or even going close to broadening their claims during reexamination. There's another form of reexamination that's been around for about 20 years called inter partes reexam. It's pretty close to regular reexamination, except the requesters, third-party requesters, are allowed basically full rights to intervene. Right? You get an opportunity to argue your case to the examiner. You can file papers responding to the assertions of the patentee during reexamination. It's a full participation. It's sort of a step towards a more adversarial process. Right? The key here is that the requester is stopped from later raising any ground that was raised or could have been raised during reexamination. Right? So that means if you raise the obviousness of a particular patent based on a piece of prior art during an inter partes reexamination and you lose, meaning the patent claim is still valid after the reexamination, then you are now judicially stopped from raising that if you get sued. Right? So you can't raise obviousness based on that piece of prior art. And the practical effect of this is that nobody really uses inter partes reexam. Right? Which I think is a pretty strong statement about the faith that people have in the PTO's decision-making process. Right? That they're too afraid to lose their rights to defend themselves in court by arguing the invalidity of the patent to use this process. Right? It's also key to note that the requester can't seek judicial review of the results of the inter partes reexamination, so you're sort of stuck with it. And that's another problem from the perspective of a requester. Right? So the upshot of this is that very few of these cases have actually happened. It was sort of an attempt to see if we could do a more robust adversarial process for post-grant reviewing. It didn't seem to work out very well, and as you'll see in just a moment, we've essentially replaced it with a much more full-blown system that should work better, although it's brand new, so we don't know. But again, I want to flag that inter partes reexamination exists, but almost nobody uses it. Okay, finally turning to post-grant review. This is a new feature, in fact it's one of the primary features of the American Invents Act that changed the law. And basically what it is this is a new attempt using post-grant reviews to try and beef up the possibilities for reviewing patents after they've been granted. The basic features are as follows. There's a request to cancel claims as unpatentable. They must be filed. There's a window. Must be filed within 9 months of issue date. The patentee can reply to the petition. And then the director must find a prima facie case of unpatentability. Or some sort of novel or unsettled legal question that requires attention by the PTO. Right? There's a new board, a patent trial and appeal board, which conducts the post-grant review. And there's a preponderance of an evidence standard with the burden on the petitioner. Right? So if you are claiming that a patent needs to be canceled, or claims of a patent need to be canceled, the burden is on you, but this preponderance of the evidence standard is different than the standard for invalidating a patent in litigation. Right? At litigation, as you know, the presumption of validity attaches, and you need clear and convincing evidence of invalidity in order to invalidate a patent. This is a lower standard. Right? Settlement is allowed. Right? It is allowed for the two parties to settle and agree as to some outcome that obviously has to be approved by the director, but settlement is a possibility. What exactly settlement would look like, nobody really knows yet, but the sense is that if the two parties could agree on what the appropriate scope of the claims were, and the director agreed that that was the appropriate scope of the claims, then that would save everybody a lot of time and money, so they wanted to allow settlement. Appeal is allowed by either party. So you can appeal to the Federal Circuit if you don't like the decision that's made by the PTO on the post-grant review or by the Patent Trial and Appeal Board. And there are estoppel effects, right? So later filed civil actions will have estoppel effects, meaning any decisions that are actually made during the post-grant review will have estoppel against you, the petitioner, in later filed civil actions. So the other thing that it does, the American Invents Act, is it also beefs up inter partes re-exam, right? So as we noted earlier in the class, because of various features of the inter partes re-exam, not a lot of people, in fact hardly any people, had used it. The American Invents Act is trying to beef this up, trying to make it a more significant part of post-grant review. It can only be requested after the post-grant review window of 9 months closes, right? And it's harder to get a petition for inter partes re-examination established than it is to establish post-grant review. So again, the idea here is we're trying to push people into doing these in a relatively short period of time after the patent has been granted. There are several reasons for this. One of the reasons is that this was sort of a negotiated deal where people, particularly small inventors, were worried that if at any point during their 20-year patent term somebody could throw them into post-grant review, that it would be very hard and expensive to enforce your patent rights, because if you tried to litigate, for example, against a larger company, they would simply seek post-grant review, and you'd have to fight sort of two cases at once, both in the courts and in the Patent Trial and Appeal Board. So this window, this narrow, fairly narrow 9-month window, makes it so the idea is that if an important patent, a patent that looks bad to people who are interested in a particular technological area, interested meaning they have some stake in it, obviously, then this 9-month window would give them an opportunity to come to the patent office and request that certain claims be canceled based on reasons of patentability. Now, after the 9-month window closes, inter partes re-examination is allowed, and there's a higher standard. You have to show that you're going to prevail, the reasonable likelihood that the petitioner would prevail. It's inter partes, so a lot of the same features are there. Settlement is now allowed, right? Again, nobody really knows yet exactly what settlement might look like in this context, but the idea, I think, is that if the parties were able to agree on the correct scope of the claim and were able to then convince the PTO that this was the correct scope of the claim, then settlement would be allowed. And no estoppel effects happen if it's been settled. Same, by the way, with post-grant review. So this is a substantial beefing up of inter partes re-exam. And the idea is that this is going to offer sort of two windows of post-grant review, right? So during the post-grant review, you can make broader invalidity arguments, right? You can there's some limits in the inter partes re-exam as to what exactly you can argue in terms of the types of arguments you can make, whereas in post-grant review, you can make almost any argument with respect to invalidity. There's a lower threshold standard for post-grant review. You simply have to show a substantial question of patentability or some novel or unsettled legal question that needs to be resolved. Inter partes review, you have to show a reasonably likelihood of prevailing in order to get that review. So the question is, at the end of the day, is this going to help, right? I mean, so reissue and traditional re-exam, reissue is still out there. Reissue is still possible for the the patentee. Reexam is still out there as well, but now post-grant review and inter partes reexam have been substantially beefed up, meaning there's sort of three processes. The reissue process, which allows patentees to correct errors that they find in their own patents, is one. The second reexam is a process whereby it's ex parte, right? There's no participation or only very minimal participation by a requester. And then there's inter partes, post-grant review and inter partes reexam, which allows pretty much full adversarial type proceedings, almost a mini trial on validity in front of this patent trial and appeal board. And the question is, at the end of the day, is this administrative review structure that we've established now after the AIA going to meet this, what we would describe as a sweet spot? Is it going to be relatively accurate, highly accurate, and low cost, lower cost than litigation, but more accurate and potentially much more accurate than patent prosecution? And I think there's some hope. I mean, I guess I would count myself among the skeptics of whether this is really going to work, because I think this idea that you can find a happy medium between sort of low cost, low accuracy screening like we do in patent prosecution, and the high cost, super accurate screening, super high cost, super accurate screening that we do in judicial review, is, it's one of those things that sounds good on paper, but you look at the details of this structure and you wonder whether the 9-month window is going to be enough to provide enough information for people who might want to decide whether or not to challenge a patent in the post-grant review process. It may be the case, and I expect it is the case, that in many times the patents that are most important to be reviewed, in fact, it's not apparent until well after that 9-month window is closed, which means I think a lot of the action in post-grant review is going to be on the inter partes reexamination, and the question is whether or not the changes we've made to that, allowing settlement, making the estoppel effect somewhat narrower, having this special patent trial and appeal board to review this, whether that's going to make it lend a sense of confidence to the decision making that's going to induce more people to use that system and therefore take some advantage of the potential cost savings over traditional litigation. And this is just now being implemented. The PTO has had about a year to implement a series of rules and to set up the patent trial and appeal board. As of last fall, this system went into operation. At this point, I don't actually know what the results are. In fact, there probably are no results yet. I've not heard of any results yet, so I think that the jury is very much out on how this is going to work. But a lot of people have thought about this and do think that this is likely to help. So again, the question is, can this be done?